Hello, this is Mrs. Blitzky, and I have notes for the law class, Chapter 4, Section 2, Criminal Procedures. So as we go along, make sure that you have your notes handy. And here we go. Let's talk a little bit about rights and responsibilities. The major objective of the Constitution is to protect individuals from certain actions of our federal government. And it's kind of believed that it's better to give individuals too much, not must, but much liberty than to allow the government to have too much power. So when we're arrested, we have certain rights to due process of law. And some of these are, for the most part, embedded within certain amendments within our Constitution. So you could look at the Fourth Amendment talking about protections against unwarranted searches and seizures, but also when we look at like the Fifth Amendment and we talk about certain rights of the accused, let alone the fact that we do have rights under the Sixth and Seventh Amendment when we talk about having a speedy trial and to have a trial by jury when we talk about civil cases. So when we talk about due process of law, it is the fundamental fairness in government actions, and it requires fair procedures during an investigation in the court. Okay, we have certain rights not to testify against ourselves, which is protected within the Fifth Amendment. And we also have the right of an accused person to have a lawyer or an attorney present, particularly at the time of questioning. You also have the right to excuse yourself from testifying against yourself. So if you don't want to say anything, you can plead the Fifth or the Fifth Amendment. Along with that, to convict, evidence must establish guilt beyond a reasonable doubt, and that means about 90% of the evidence must support a guilty verdict. One of the things that you might find when we talk about due process of law, something that originally wasn't necessarily, I think, what our founders thought when they crafted the Fifth Amendment, but kind of came about many years later, particularly in the 1960s, when we talk about an event that happened in Arizona. And we might hear a little bit about the Miranda rights or the Miranda warning. And if you can take a look down here, it's the right to remain silent, understanding that anything that you would happen to say as an accused person could be used against you in the court. You also have a right to talk to an attorney and to have them present at the time that you're being questioned by law enforcement. If you can't afford an attorney, you do have the right to have one appointed. Doesn't necessarily mean that you're going to get a quality appointed attorney. You may get an attorney, but they may not necessarily have a background in criminal law, and that's the sad part. Okay, responsibilities of the criminal conduct of others. A person who aids in committing a crime is also guilty of the crime. So when we talk about individuals who happen to be acting as a lookout, they are just as guilty as the person who is committing the act itself. One who plans a crime or otherwise intentionally helps is also guilty of the same crime. Officers of a corporation may also be criminally liable for the actions of their managers or workers. And this is kind of an important factor when we talk about aspects of the law and how it is in regards to business. So as an owner of a corporation, those people who are working under me, I am just as responsible for my own actions as I am for their actions while they are at work. And so if I am not taking steps to make sure that people are acting and behaving in a fair manner, I could be charged. Defenses to criminal charges. States must prove that the defendant is guilty beyond a reasonable doubt, which we had mentioned a moment ago. A defense. So when a person is accused, they have the right to basically present their case to the court as a defendant. So a defense is the legal position that allows a defendant to escape the criminal liability. And there are a couple of different types. There's procedural defense, which is talking a little bit about how perhaps maybe in the process of being arrested, that maybe evidence wasn't collected in a proper manner or was mishandled. And then there's substantive defense, which is probably getting more into the true actions of what was going on as far as the act of the crime. So our procedural defense, based on problems of evidence, we just mentioned. Substantive, this is disproving, justifying, excusing the alleged crime, discrediting certain facts that the court has brought. This is a lot of times where you see, perhaps maybe in a courtroom drama, where an attorney might get up and perhaps use an objection based on the types of questions that maybe the prosecution is asking, whether or not they're asking leading questions, or if they are using things such as hearsay within the court to kind of try to, pinpoint maybe a crime onto a person. Self-defense is something that is not necessarily recommended, but this is used, it's kind of the use of force that appears to be reasonably necessary to a victim to prevent themselves from serious bodily harm. When we talk about it, perhaps maybe in terms of representing yourself in the court, it's not necessarily recommended. There are some individuals that dismiss their attorneys if they're a defendant, wanting to prove that they could probably represent themselves better. In many cases, they do so with the hope that maybe trying to establish themselves not criminally fit to stand trial, perhaps maybe reason of insanity. It might be the motive here. In many cases, that does not necessarily work. So, criminal insanity, this generally exists when the accused does not know the difference between right and wrong. Does not necessarily talk about age as a factor here, but when we talk about probably mental illness, when we talk about it in terms of psychology, psychologists typically don't use the term insane. That's more of a legal term than it is a psychological term. But if an accused individual is deemed insane, then for the most part there is no crime, and thus the defendant must prove their insanity. And sometimes this might be done by taking a battery of different psychological tests, such as the Minnesota Multiphasic Personality Inventory, which is purposely looking for different forms of mental illness. Immunity, this is freedom from prosecution even when one has committed a crime that's been charged. Sometimes this is granted in exchange for getting testimony against another criminal. So we may have an accomplice, and we might get them to testify against maybe a conspirator, and by having them do so, we might grant them immunity and lessen the charges against them, and perhaps maybe lessening the amount of time that they will spend incarcerated. The government may grant immunity to get a reluctant witness to remove the privilege of self-incrimination. If they happen to refuse to testify, meaning that they've agreed to the immunity, but when they get to court, they don't want to testify, then they would be charged with being in contempt of the court. And by refusing to testify, then they could be punished by imprisonment for doing so. Punishment for crimes. Punishment is any penalty provided by the law or imposed by the court, not to remedy a wrong, but to discipline the wrongdoer. And for the most part, the goal of punishment is always to deter similar behavior by others. A plea bargaining, the accused agrees to plead guilty to a lesser crime in exchange for having the serious charges against them dropped. So rather than perhaps maybe being charged of first-degree robbery, the individual, basically pleads guilty, but maybe to a lesser charge that might mean a fine or a very short imprisonment. The accused, for the most part, they give up their right to a public trial to avoid a greater crime when they do accept a plea bargain. And what's interesting is a lot of cases in the United States are actually resolved in this manner. Not to say that we don't have a lot of court cases that go before the courts, but there are far more cases that are, for the most part, having to avoid the public trial by using the plea bargaining, saving the courts a lot of time and money. Thank you very much.